All right. Hello, everybody.
Hi, welcome to the webinar today. Go ahead, Melissa, get us started.
Yeah, sorry for a couple minutes delay, but we're getting logged on and had a couple of technical difficulties, but here we are. We are going to be talking about some family law considerations in the COVID era. I have Michelle Dellino here, the owner and managing attorney at Dellino Law Group, and she's going to be leading a discussion about family law considerations in the COVID era and all kinds of different things to consider during this time when it comes to your family law case. I'm Melissa Rosenberg, and I'm a licensed therapist. I run a private practice and work with clients, I specialize working with clients in relationship transitions. In particular, I work with a lot of clients who are going through divorces and separations. And I'm here today to kind of act as a co-host and help get through this webinar with Michelle. What we're going to do is have Michelle go through some different bullet points and topics related to the COVID era and family law, and then we're going to take questions and answers. So I want to alert you to a couple of things about the format of this before I turn it over to Michelle. As you'll see on the bottom of the Zoom screen, because we're in a webinar, there's a Q&A option. If you have a question that you'd like Michelle to answer, go ahead and plop that into the Q&A. If you want your question to remain anonymous, mark that you want it to be anonymous. So otherwise your name would pop up when the question becomes answered. You can also chat if you would like, it's another way, but I think the question and answer is a better option to use as far as this webinar format is concerned. So hoping to answer everybody's questions and give you guys some great information today, and thanks for joining us. Okay, go ahead, Michelle.
All right, great. So I'm Michelle Dellino with Dellino Law Group, like Melissa said, and thanks for joining us today. So we haven't done a webinar in a while. We were doing these about every month, and we thought we'd take a break because I don't know about you, but I kind of have Zoom fatigue. If you are like me, you spend a lot of time talking to people like this. I prefer to talk to people in person. It's nicer, you connect with people better that way, and it's just easier, but that's not what we're doing anymore. We're doing this. So I do this almost all day now, or I talk on the phone, and you probably do too, no matter what you do. Everything looks different. So I started thinking about what are the things we should be talking about, and we should probably be talking about COVID, and we should be talking about how is that impacting people still, because we're still having this conversation, we're still meeting on Zoom, we're still doing all of this stuff, and it's the end of the year. And I don't know about you, but I didn't really think we'd still be here at the end of the year, or at least I didn't want us to be here at the end of the year, but here we are. So what we're going to talk about today is we're going to talk about what's the current status of COVID in the courts, what's the current status on what that means for parenting situations, what are the other considerations that you might not have thought about that we're seeing kind of pop up more and more and more, as far as powers of attorneys, healthcare directives, things that you might want to think about, if not for yourself, for other family members, just things to know about that I'm kind of seeing come up, or unfortunately things that people wish that they had that they don't have in place, and then it kind of gets to be a situation where it's too late, or you're not able to execute those documents, and why you might want to have them. So we'll talk about those things. We'll also talk about other things that you might want to do for yourself, and then we'll answer your questions. So I'm going to run through a bunch of things. If you have questions, like Melissa said, just kind of table them. You can pop them into the Q&A whenever you really want, and then we'll get to them. And like Melissa said too, go ahead and mark them anonymous if you don't want your name to pop up there, which is totally completely understandable. So first of all, what's going on with court? A lot of people want to know that. They want to know, are we still going to court? If it's COVID, can I get a divorce? Can I, if I have a parenting dispute, can I go to court to fight about my parenting plan? What can happen? And yes, you can still go to court. It just looks different now. You can still get a parenting plan. You can still do all of those things, but let's talk about what that really looks like. Court hearings right now are almost 100% virtual, at least in King, Pierce, and Snohomish County. So in King County right now, where we mainly practice, and most of our clients are, although we do have clients in other counties as well, all of the hearings are being held mostly telephonic. So what that means is the court will call, the court's open, so the courtrooms are open, but nobody's there. The the commissioner or judge is there, the court staff is there, but none of the litigants and none of the attorneys are there. The court will contact you ahead of time, the attorney, and they'll call the attorney. They'll also call the parties. Everybody will be dialed in, and then they'll have the hearing open in the courtroom, because courts in Washington have a policy that they have open courtrooms. So we'll have the hearing over the phone. Everybody will talk over the phone, and then we go through, it's a little bit of an annoying system, but we go through a system afterwards where then we work out the orders electronically afterwards, and we send things back and forth to get the orders back. So telephonically is one way. Another way is via Zoom. Some hearings, usually not family law calendar hearings, but hearings with the judge, are very often via Zoom. So the court will send out an invite and everybody will dial in just like this, and we'll have a hearing via Zoom. Sometimes emergency hearings are via Zoom. Hearings that are specially set before a trial judge are via Zoom, so everyone actually appears on video. That's not uncommon. Same for criminal cases. Some criminal cases are happening in person, but more and more, especially because those are very crowded calendars, the court is now trying to do things via Zoom. So that's what's happening on day-to-day calendars. For trials, those are still happening as well, although there's some delays, and I'll tell you about that in a minute. But those are now no longer where we all go down and bring our big binders and set up for the day or week or whatever. Those are via Zoom as well, which is a totally different experience, where testimony is via Zoom. It's a very different experience, and it can actually take, in my experience from having done this now, a bit longer. There are pros and cons to that. So you still have access to the court system, but it's taking longer. The court's capacity to deal with these things, they have learned a whole new system, just like many of us have in our jobs, and they've had to make big accommodations to do that. And it's still a work in progress, so it's not perfect, but they are doing everything virtually. Another thing to know is that right now in King County, they have completely put a stop on all in-person jury trials. For a while, they were doing jury trials in person, and they were using all this social distancing and everything else. All jury trials have completely stopped. So what that means is if you have a family law case and it's coming up in the late winter or spring, it's probably going to get pushed out. And the reason why is that family law cases are a lower priority after criminal cases. Criminal cases involve constitutional rights. So those cases have to be heard by the court first. And when the court gets backlogged on those, criminal cases go first and family law cases get pushed out. So I just had a pretrial conference for a case where the trial date was getting continued to March, and our judge said to us, I really hope you guys can settle the case, and if you can't, you might want to consider using private arbitration, because by the time that your trial date comes in March, it's probably going to get pushed out. So it's good to know that if you have a trial date coming up in late winter or early spring even, it might not happen then. So the court system is really backed up because of COVID. We're still trying to recover from everything last summer when the court was completely shut down. So you have to be patient. And then what does that mean about getting a date for like a temporary parenting plan? What if you need a parenting plan right now? It used to be before COVID, you could just set a court date and get into court in 14 days. It was a great system, or at least we thought it was, and it worked great. That's not the case anymore. If you need to get a court date, if you have an emergency, you can still do that. You can still get a court date. It used to be we walked down to the ex parte department, you could go in twice a day and get an emergency hearing. That's not the case. I can still get into court same day. We just have a little system that we go through to email them, and then I get to appear via Zoom. I appeared via Zoom on Wednesday right before the holiday, and that was fine. And I set that up same day. So you can still do that, but how do you get that hearing 14 days out? You don't. Temporary hearings now are capped, and those hearings are being set like a month or two ahead of time. So you really have no option for very quick relief in the court, and that's an issue. However, that being said, there are other ways that you can deal with temporary orders, and we'll talk about that in a few minutes. So COVID. It's impacted the courts, it's impacting timeliness in getting things done. So everyone's adjusting to how to get things done and how to make it work. So we're basically doing kind of the best that we can. Like that's pretty much what we have to do. So what's happening with parenting time in COVID? That's another really big question. Everybody knows right now, it's not the same as the stay-at-home order that we had before, but there's very big restrictions on what people should and shouldn't be doing. There were limits on there still are limits on gathering outside of the home that are affecting holidays. Don't gather with more than 5 people outside your household. I mean, there's definite mandates that are put in place by our governor, things you shouldn't be doing. What does that mean for your parenting plan? A lot of people ask this question. People were asking it in the spring when we were under a stay-at-home order, and what does it mean? There was a lot of uncertainty then. There's more clarity now, so that's good. But there's also a lot of gray area. Some of the uncertainty is, what if I have a co-parent and that co-parent is not following the same social distancing protocols, or not following, or I believe, because you might not necessarily know, but they're not taking the same level of caution or care that I am? What do I do? What does that mean? Do I have to send my child for their residential time? Or do I have to leave the home to go do that exchange? What does that mean? Well, the governor had clarified previously that parenting plans are not suspended during COVID. So, excuse me. Thank you. Parenting plans are not suspended during COVID. So even if you have to leave the home to carry out essential functions, parenting is an essential function. So if you can go to the grocery store and stop and shop, you can go and exchange your child. What do you do though if you believe you're parent A and you believe parent B is doing something that's putting your child at risk? That puts you in a tough situation. Do you send your child anyway for the residential time? That's the big kind of $1 million question that we get asked all the time. And the answer is not cut and dry. The answer is that it depends. I am really hesitant to give you like a blanket answer on that, because the answers to that are very fact specific, but it definitely depends. If you have reason and you have personal knowledge that your child is at risk for something, as a parent, you always have a right to say it's a dangerous situation. Just like if you saw that your child was going to go into the street, you would pull your child back and not let them go into the street and be hit by a car. If you have a reason to believe you're going to put your child in a dangerous situation, as a parent, no matter what, you have every right to say, I'm not going to put you in that situation. However, if your belief is just, I think that might be happening, but I don't really know. If you don't really know, you have to be careful about maybe being seen as using COVID as a reason not to honor the residential schedule. There were cases earlier in the spring and summer that focused a lot on, are you really withholding the child? Do you really have a reason to believe that there are issues going on over there? And what's this really about? And there is one thing that is certain. If for some reason there's travel involved, or if there's some reason the parenting time can't happen, you just need to know, hey, I can't make this parenting time happen, but I am going to definitely have to offer makeup time later. Liberal makeup time, day for day makeup time, maybe even more makeup time if you're missing a special occasion. That is the expectation in the courts right now. That's the expectation between practitioners and parents, that parenting time should be honored, and if it can't be honored for whatever reason, makeup time is the expectation. The child, your child shouldn't suffer, a parent shouldn't suffer for not seeing their child because the pandemic's going on. So makeup time should happen if, at a reasonable time. So that's something the court absolutely expects and wants to see. Another thing too, before I really move on from this, is how do you resolve disputes over this kind of stuff? Because this is the other thing that comes up. Well, I want to take my kid to this or that, and that's parent A, and parent B says, oh, I don't think that's a good idea. There might be too many people there or whatever, and it's a joint decision. Because that's what always comes up. It's a joint decision about an activity or something. Maybe it's an extracurricular thing, although there's not as many of those going on right now, but they still come up, and there's a dispute about what to do. Well, your parenting plan is going to have your dispute resolution. Sometimes that's mediation, sometimes that's arbitration, or for some people, that means going right to court. Well, going right to court is not as easy as it used to be, like I said, because you're going to wait. And what I really encourage people to do is use your dispute resolution in these kinds of situations. If you don't have a good co-parenting relationship, that's a whole other thing. And we can talk about that if we have a few extra minutes. I have ideas about that all the time. But if you can, try and work it out and try and think about ways that you can be flexible and still making a situation happen and maybe compromising. But if you can't, get to your dispute resolution as soon as possible. If it's mediation, mediations are being done just like this via Zoom. This is how mediations are being done now. You can schedule a quick half day to resolve an issue. There are many mediators that are open to making that happen. Some mediators are still doing in person, socially distanced, but not very many. Almost everybody is doing mediation via Zoom. If it's arbitration and that's in your parenting plan, excuse me, arbitration is typically via written submissions. So you request a briefing schedule, you can submit your dispute and you can get a decision. But a lot of the time, if this is about something that needs to happen as soon as possible, there's not always time for that. You just have to talk. You have to try to work it out. Before anybody runs to court, that's kind of what people want to see. If you have to get an attorney involved to try to help you communicate, if you really have poor communication with this other person, sometimes that can be helpful too, even for a specific issue. Sometimes that can escalate things. So it really, depends on the situation. But do what you can to try and work things out. Because that's eventually, if you end up in court, what the court wants to see. They want to see that you made reasonable efforts to try and work things out. And they want that to be documented. And then yet you tried to use your dispute resolution, especially now more than ever, where you really can't go to court. It's just not realistic or possible for you to do that very quickly anyway. It's different if it's like a school issue or something that's going to require time, but otherwise it's pretty hard to get right into court. I think Melissa, do we have some questions? I can answer some questions before we move on. That might be a good idea. You're on mute.
All right, yes, we do have a couple questions here. Okay, here's a question. Have you seen issues with a parent losing a job and being forced to move away, forcing change of custody out of court?
Yeah, sure. I mean, relocation comes up all the time. It comes up all the time, whether it's during COVID or not during COVID. If a parent loses a job, that can be a reason for a move. I can tell you just in general about all the time. We handle relocations. It's a very common situation. Relocation with a child, you have to file a notice of relocation. Washington State has a specific relocation statute that you have to follow. And you have to follow notice of relocation. If you're moving from Seattle, let's say you lived in West Seattle, and you were moving from West Seattle to over to Lake Washington on the other side of the lake to Kirkland. You would have to file a notice of relocation because you were changing school districts. Or let's say you're moving from West Seattle to Portland. You'd have to file one because you're moving school districts. The rule is that you have to file a notice of intent to relocate if you're moving with your child, whether you're moving across the city, like to Kirkland, or whether you're moving out of the state. It really doesn't matter. You still have to file that notice of intent to relocate if you are the primary parent. And that is if you are the parent that the child resides with more than 50%. Actually, I think now it's more than 47% of the time. The statute's changed a little bit. But if the parent loses a job and that's forcing a relocation, there are a number of factors that the court's going to consider surrounding your relocation. Are you moving somewhere where you have another job? Because the court's going to want to know that. Did you make reasonable efforts to get a job here where the other parent is? The court's going to want to know that. Where is, what are the reasons to move? And I could go through like all of 11 factors that we could talk about. That could take the rest of the time. So I'm not going to do that, but yeah. And then you're going to have a dispute resolution requirement, which is kind of what I was talking about a few minutes ago. So you have to file your notice of intent to relocate, and you have to file that a minimum of 60 days prior to your move. And then the other party, the other parent, has to respond. They have 30 days to object to your relocation. If they don't object, it's presumed that you can move. But most of the time they probably are going to object. And then there's another procedure that happens from there. However, you do have a dispute resolution requirement, so you're going to probably mediate on whether the move is going to happen, and that will happen out of court. So you might want to set an early mediation as soon as you can to figure out, hey, am I going to be able to move or not? And try to negotiate that. So yes, we see that happen all the time. If you're really looking at relocating, I suggest you get on it and you talk to an attorney, because it's a procedure that you don't want to mess up. I actually have also seen people ordered to move back because they didn't do it properly, and that can be really, really damaging.
All right. Got a couple more questions here. Okay, my ex-spouse will have our kids over Christmas this year per the parenting plan. I know he plans to travel with them out of state during that time. I do not feel comfortable with that, as I'm not sure it's safe. What do I do?
That's tough. I'm just gonna actually talk about travel next. So good, that's a very timely question. If, you know, and that's, again, this really comes down to communication. I guess questions are, is the travel necessary? Is it to see other, family? Is it to, like, was the trip pre-planned? There's a lot of questions about this. Have you said to the father or mother, I don't know what it is, but to your other spouse, former spouse, have you said, I'm not comfortable with the travel? Have you asked for the trip to be postponed to the next break, whether it's midwinter break or spring break? Try to negotiate it first. Try to seem reasonable and negotiate it. If they're not willing, then you could, just be really clear that you want testing before and after the trip. I think that's perfectly reasonable. Right now, obviously, travel to another state is not prohibited, and technically that parent can do what they want to do on their residential time. But at the same time, I think it's reasonable to try to put some parameters in place. And also, there's reminding the other parent that there's a required, right, as of now, it may change, but there's a required 14-day quarantine for the children when they come back. So is it really going to be possible to quarantine the children for 14 days? And if that's not possible, I think it's worth it to entertain a conversation with the parent and say, if this is a trip to see your family over the holidays, or if this is a trip for whatever, can we talk about maybe postponing that trip to midwinter or spring break when things look a little different? If they're still not willing to, you may have to deal with that, but at least try to negotiate some parameters in place. And if you absolutely don't agree, try to exercise dispute resolution as soon as possible, and say that this is something you don't agree with, and maybe you guys can work it out in your ADR. And I think what we should do, Melissa, is let's take like 2 or 3 more, and then I want to bang through some more stuff so I don't not get through it, and then I'll take more.
Good plan.
Go ahead.
This one's a little bit similar, a little bit reverse.
Sure.
I'm out of state attending school. I have a parenting plan that allows a week-long visit every 6 weeks. Mm-hmm. We verbally agreed on skipping November for cost reasons and agreed on 2 weeks at Christmas on a verbal agreement. I purchased tickets to come down and get my daughter. He has not purchased a return. The ex is stating that travel is dangerous and he does not want to let her visit. He is also backtracking and saying only 1 week now, like our agreement says, and not honoring the verbal agreement for 2 weeks over Christmas.
Well, I don't know if you have a parenting plan. If you don't, that's not good.
Right. She said the parenting plan was a week every 6 weeks, but they had verbally agreed to skip November and do 2 weeks at Christmas. And now he's backtracking and also stating the travel is dangerous.
Well, I mean, this is also worth noting too, and I'm not, just so we know, like, I'm not a medical professional. My opinions are simply my opinions on these issues. These are not legal opinions. Travel in and of itself, according to the CDC, is not dangerous. This is my opinion. It is the reason travel is discouraged is to discourage gathering. I've actually been doing reading on this. So this is my opinion, and you might want to point this out. It is to discourage gathering. And so a parent traveling here to see their child, that you're not asking the children to travel. You are traveling here to see your child, I think is what you're saying. So what you could do is you could say that you are willing to test when you get here, and you maybe even do 2 tests. Test immediately when you get here, and then test a couple days later.
It sounds like they would actually have to take the child to Alaska. Their they're coming to get the child and bring them to Alaska.
Oh, okay. I thought you were traveling here to see the child.
Yeah.
Okay. All right. Well, again, still, if you're having the child travel with you, you're traveling here to get the child and bring the child to Alaska, and you haven't seen the child in 2 months. It's unfortunate. This is the other thing too. This brings me to another point. Whenever you reach what you think is a verbal agreement with someone, that doesn't mean anything. It'd be nice if it did, but I would, especially when it comes to visitation and maybe you only see your child once a month, this doesn't really help you now, but it would help you if you have it at least in an email. That's not a binding agreement either, but at least having it in an email helps you if you need to try to enforce it. But I would always recommend that any change to a parenting plan be done through what is called a quick CR2A. That is a quick binding settlement agreement. That's something you can always do really quickly. That might not help you now, but it might help you in the future. With respect to this situation, I can't really give you legal advice on what to do because, you know, we're not in a consultation about your situation, but what you could do is you could say, look, you know, this is my time to see the kids. We'd agreed upon this. If you're not willing to do it, we need to have dispute resolution right now. That's what I would do. I would say we need dispute resolution right now because we had an agreement, even though this isn't what the parenting plan says. This is exactly a dispute resolution situation because you risk not having your residential time with your kids when you haven't had it for months. I would say, I don't know what your dispute resolution is in your parenting plan, but I would ask for it ASAP, like immediately, because I would say that essentially your spouse is withholding the children if you're not able to have the visitation locally. That's the other question too. If you're not able to have, maybe you're able to have it locally, you know, if you really won't agree to the travel, but I would argue that the travel is not really the dangerous part as long as the kids test when they come back and can quarantine. Although I think maybe the opposite argument could be made where it could be difficult to quarantine the kids when they come back. I don't know if your kids are participating in some kind of a program or whatever, but that's another concern. So you kind of have to look at what are the issues before and after the travel? Can you deal with the testing before and after the travel? And can you deal with the fact that the child may need to be in, whether it's a daycare setting or some kind of a alternative school setting, whether it's the YLEAP program, any of these other programs, pod programs that people are doing, and can you work around the quarantine? If you can't, the travel might not be possible and you might have to make alternative plans. If you can, then maybe the travel needs to happen and the other parent needs to be flexible on their end. But either way, you know, I would kind of figure out the logistics on your end, and then I would get into your dispute resolution as soon as possible if you can't work it out with the other parent.
There's a quick follow-up from this person just saying that they do not have an attorney hired, but her ex does. And the case is in Kitsap County, and they're wondering if our firm takes cases outside of King.
Yeah, we take Kitsap. We take King, Pierce, Snohomish, Kitsap, and occasionally Thurston. So yeah, you're welcome to call us. We actually do take Kitsap fairly often because there's not really a lot of people that like to go to Kitsap, but we don't mind. Yeah.
I have a couple more questions, but we'll move on. I have a couple questions coming through chat and email as well. So we can go ahead and keep going through your agenda.
I'm going to go through a few more things and then we'll come back to those. We will get to your questions, I promise. I talk fast, it's all right. I want to talk about contempt versus co-parenting. And this kind of leads into, this is kind of some of the stuff that you guys are asking about. So this was a big issue earlier this year regarding what do I do if we can't come to an agreement and the other co-parent won't send the kids, right? What do you do? What do you do to enforce the parenting plan? Do I bring a motion for contempt? That's kind of everybody's big nightmare, right? Because if you get 2 motions for contempt based on the parenting plan in a 3-year span brought against you, it can be a basis for adequate cause to change that parenting plan. A lot of people don't know that, but it can. Basically, finding a contempt is what a lot of people fear. However, I will tell you that for contempt to happen, it really needs to be that you were like deliberately not following the plan. And it needs to be that it was, you know, bad faith here. And I will say that in this situation, you know, if you're not sending your children because it's a safety issue, like we were talking earlier, where I'm like, don't let them go into the street, or don't let them go if, you know, parent B is like a known COVID denier or something like that. And that does happen. And they're obviously, you know, exposing your child, or if you have personal knowledge that it's a dangerous situation and you don't want to send your kid, that's different than just disagreeing about travel, by the way. But, you know, if you've really tried to work something out and it's a dangerous situation and you're saying, I'm not putting my child in this dangerous situation, another party might threaten you with contempt, but that doesn't necessarily mean it's contempt. You could have a very defensible reason as to why you did not send your child. On the flip side of that, if you are the parent where you're like, hey, I want my residential time, and the other parent's like, yeah, no, I'm not putting my child on that, in that car, or I'm not doing this or that, you could be the one who is needing to bring a contempt motion saying, I want my time. And you could very well get one because the other parent is not acting in good faith. So I'm not saying either party's right or wrong. And I'm not talking about any of the situations you just mentioned, but you need to be very careful if you're bringing in contempt motion, because courts really don't like contempt motions on residential time. They'd much rather that you co-parent and try to work it out. So what I'm trying to get at here is what I was talking about earlier. Before you go to court, it is worth your time to document your communications with your co-parent, and do that via email if that's how you communicate. Do it via text if that's how you communicate, although I really disfavor parents co-parenting via text. You should be able to have a mature adult conversation. You had a child with this person, although I will say we deal with a lot of high conflict parents here who I don't know how they ever got along enough to have a child, because they don't get along now. It's like that never happened. And so, we'll just get pages and pages of angry, high stress text messages. And I'll tell you what, when we have to submit those to the court doesn't want to see them and just gets mad. They'll look at them, but they don't like it. A lot of the time parents move towards using Our Family Wizard or Talking Parents, which are parenting applications. I could do a whole program just on that. But those kinds of applications are places you can document communication. If you get along with your co-parent, great. Sit down, well, I guess maybe not now. I would have said before, sit down over coffee and chat, but whatever, have a Zoom conversation, whatever you need to do, talk about it and try to work it out. And then send a follow-up email and say, hey, so-and-so, it was great talking to you about our kid. I really hope we can work this out. These are the reasons that we don't agree. This is the compromise I'm willing to make. That kind of communication is not only just great for you to have in general, but it's great for documentation to show that I tried to work this out. And then if that doesn't work, hey, we tried, we couldn't get there on our own. Our parenting plan says specifically, I think the verbatim language is, there will be times when you and the other parent disagree. That's what the parenting plan says. That's what this process is for. We need to now invoke that process and do it as soon as possible. Don't wait. And then do those things before you go to court. So anyway, my point is use contempt motions sparingly. If you're defending on one, get help, get an attorney involved. If you're bringing one, get an attorney. The reason why is that if you are found in contempt, the statutory language in Washington, it says that you shall pay attorney's fees. So if the other party has an attorney, you shall pay their fees if you're found in contempt. So be very careful. It's just a sticky situation, and it's better to just avoid contempt in general, bringing it or being on the other end of it. I want to talk really briefly before we get to more Q&A about what other things to consider. And this is stuff that I normally would have in a totally different conversation, like about estate planning, but it's been coming up, so I feel like we should talk about it. And this is powers of attorney, which is just something that people don't even like to think about or talk about. First of all, nobody likes to talk about getting sick. Nobody likes to talk about dying. Nobody likes to talk about any of this at all, period. And I don't know about anybody that's watching. I don't know how many people here may have or may not have been impacted by COVID directly or other medical issues. But you know what? It happens. It happens now more than ever, but it happens in general. It happens with aging. It happens now with pandemic more than ever. It also happens we talked about, a lot of people have asked about travel, which travel is like such a hot button issue. I don't know about you. I love to travel. It's what I do to get away from stress. And so this whole situation is just kind of really messed with things for me, but you can get stuck somewhere too now more than ever. I was actually traveling in Italy right before all this happened in February, and my husband and I were in Italy, and I remember we almost were thinking, what if we don't get out of here, and what if we can't get back, and what if we can't get back, who will, well, I was even thinking like, gee, I should probably have a durable power of attorney for my parents or my brother or my sister to be able to access my finances? What if somebody needs to do something and we're stuck here for a while because everything was just blowing up at the time? And luckily we got out and we got back. But what if we didn't, in time? And what if we were stuck there for like a month, which easily, we didn't know at the time, it could have happened. So it made me think, as things have kind of evolved, and I've had other clients in this situation, that everybody really should have certain pieces in place that are very, very, very simple documents to have executed for you. And they really are, there's three main pieces to any estate plan that somebody should have. One is a last will and testament or a trust. And there's different kinds of trusts. I'm not even going to get into the last will and testament and trust piece today. That's an estate planning conversation. I'm really going to talk about the functioning pieces that you should have that are ancillary to that. And one is a durable power of attorney. A durable power of attorney is something for during your lifetime. So don't get scared. It's not if you die, but it is if you are hospitalized, if you are stuck somewhere, if you just need somebody to act on your behalf. Having a durable power of attorney is huge. You can define what are common ways to use that power of attorney are for accessing your financials, are for undertaking transactions involving real property on your behalf, transferring title for things on your behalf. You can define the scope. It can be really narrow. If it's just like, I want somebody to be able to sign the titles for these vehicles I'm selling, you could make it really narrow and specific to that. If it's, I want somebody to be able to access anything, sign checks on my behalf, you can make it super broad. Who writes checks anymore though? So maybe that dated me, but you know the point. It could be as broad as you want it to be, or it could be as limited in scope. But that document, you could, your parents should have one if they're getting older. You should have one because you never know what's going to happen. But a durable power of attorney is really important, especially now. I've noticed more and more where people don't have necessarily the same last name as their spouse, because your spouse technically should be able to do these things for you. Well, number one, what if you're with your spouse? So sure, I'm somewhere with my husband, and then, my husband would normally do these things for me if I'm not available to do them. Well, what if he's with me? Then who's going to do it? If we need somebody to do something for us? Nobody, right? So there should be somebody else. And number two, I don't have the same last name as my husband. So someone might not know that he's my husband. It'd be very possible for that not to happen. So it would be good to have something naming him and then an alternative. That's a very smart thing to have for most people these days, because especially too, unfortunately, in same-sex marriages, it'll say, there's a lot of times people will say, oh, I don't even know if this person is your spouse. Well, that's ridiculous, because of course they are, but that comes up a lot. So durable powers of attorney, really everybody should have one. The second thing that's really coming up with COVID, number one, well, first of all, with the durable POA, how many people are hospitalized and wishing that they had one, and then not able to get into a hospital with a notary to have one executed has been a really big thing. It used to be that you could easily have, hospitals have notary, you could easily have somebody go in and execute one. That's no longer an easy thing to do, and that's no longer simple. So I've had people where they're like, oh, I want to just send a private notary in. I used to be able to do that all the time. Now you cannot. So if you have somebody in a hospital and they don't have one, you're kind of out of luck. It's a really bad situation. So you want to have that done ahead of time. Healthcare directives and powers of attorney are the second thing I'm going to talk about briefly. When you go into the hospital for a major procedure, you're often asked to sign a POLST form asking if you want life-saving measures. This is different. This is different than that. So a healthcare directive is going to talk about specifically where, what you want in certain instances and designating someone to carry out those wishes, and then also putting you in a situation where you're trusting someone to do things beyond that if you're not able to act on your own. I can't tell you enough how invaluable that is, because the last thing that you want if you're, it doesn't necessarily mean you're dying, but if you're in a hospital and you can't make decisions, or you're under anesthesia, or you're just out of it or whatever, or your parents are, you don't want your siblings fighting over it. You don't want next of kin, whoever that might be, if there's multiple people fighting over it, or if there's nobody and it's left to other people to fight about, you don't want that. Or if it's next of kin as someone that you don't want that either. So these are very important documents, more than ever now, especially again too in Washington. A healthcare directive absolutely has to be witnessed by 2 people to be valid. So you cannot do that in a hospital setting right now. You need to do that now, before you're in a hospital setting. So I can't stress that to you enough. I'm going to take some questions because I think there are some, and then I can talk more, but I'd rather talk about what you want than just me. So Melissa, what do we got?
Yep, we have a couple questions. I'm going to read this one that came in on email. Okay, what rights will my soon-to-be ex have if his name is only on the mortgage, not on the deed?
Next, soon to be on the mortgage and not on the deed. Well, if it's on the mortgage, then it's probably community property. I mean, if you have, this is a community property question, so it's a little off the scope of what I was talking about, but I'm happy to address it. If you have a soon-to-be ex, it doesn't matter if they're on the deed. In Washington, community property, name on title doesn't matter. If you have a piece of property that was purchased during the marriage, it's community property. You could have been the only person on title, and maybe both of you were on the mortgage, which I don't know why you'd do that, but let's say you did. Let's say you're both, maybe it was for credit purposes, although usually a lender will require you both to be on the underlying note as well, but and title. But let's say one person's on the mortgage, both people on the mortgage, and somehow somebody managed to be the only one on the title. It doesn't matter. It's still community. So that's a community asset, and that's subject to division by both parties. So you're gonna have to both talk about that, and that's gonna be subject to division.
Thanks. Yes, that one was a little off topic, but thanks
Oh,
for
it's a good question.
We'll circle back. I have a couple more more COVID related questions here.
Sure.
Best tips for parenting plan related to COVID situations, this time brought up with a high conflict parent who's not the primary.
That's a great question. Clearly defined, because high conflict parents, high conflict people in general run in a lot of different varieties. High conflict people can be a lot of different types of people, so I wouldn't say it's a one size fits all situation. But I find in parenting plans, the more well-defined things are, the less ambiguity there is, the more that it's clear about start and stop times for things, the more it's clear about exchange points for things, the more it's clear about really absolutely everything, have every little detail spelled out, the better off you're going to be, because a lot of the time high conflict people will seize any kind of ambiguity as a point to create conflict and kind of keep that conflict going later, which is really, really bad. You don't want that. You don't want that. You absolutely don't. So I would say that without knowing a lot about the high conflict parent, you would want as clear language as possible. You would want also too, if you have somebody who's not the primary, a lot of the time they're going to feel like anything you do, you're trying to limit them. You're trying to, somehow like shaft them, for lack of a better term. So a lot of the time making them feel like, they're part of the decision, even if they're really not, making them feel like maybe you took some of their idea and incorporated it into something, getting their buy-in on things a little bit can be a path of least resistance to getting agreement. But my best tip is clear and concise language, and making it overly inclusive at the same time.
Hold your boundaries.
Yeah, boundaries, exactly. Same, Melissa's right about that. Boundaries. Yeah, hold your boundaries. Don't let them keep going and pushing. You give these people an inch and they'll take a mile, especially people that have narcissistic traits.
Okay, what is the best option if the other parent is refusing to commit to dispute resolution or mediation per the parenting plan?
Oh, that's a great question. I just dealt with that recently. If they're refusing to commit and there's an absolute issue, you can bring a motion, which I hate to do, but had to do that not that long ago, where somebody won't mediate. Well, they have to, they're required to. And if they won't, contact them, put them on notice that these are the issues in the plan that we don't agree about. These are the disputes we're having. I'm telling you now that I'm invoking our dispute resolution. If you do not agree, I will be bringing a motion and asking that you pay my fees for me having to waste my time. We have this parenting plan. We got this in place. This is the protocol. You're not doing it. Please don't make me waste my time and do this. Like, I'm asking you not to. Again, communicate with them, over communicate, document it. If you don't, you're gonna have to have the court order them to do it, which is so bad. I mean, don't get into that. Like, I'm telling you that, and you're the one that wants to do it. So that's not helpful. I wish they were here, because I would just be like, just don't. It's just not worth it. But that's what you have to do, because this is the thing. A lot of people don't understand this either. A parenting plan's a court order. Like, they have to follow it. And sometimes when they don't, then you have to get the court to order them to do it. And that's just, for lack of a better word, it's a waste of everybody's time and effort. But a lot of people treat these plans like they don't matter, and that is unfortunate. And what's even more unfortunate is that with how bogged down the court is right now, the court just, you know, it's kind of been allowed to, a lot of things have been allowed to drag on and on and on because of how things are with COVID.
All right, let me shoot you another one here. This is a follow-up to the earlier question about the parent losing their job and having to move, probably in the COVID era here. So the moving, this is kind of a specific situation. The moving parent is this step, sorry, one parent is remarried. Okay, the custody is split. The move has caused a friendly email agreement to move to like a 70-30 school summer split, with the moving away family having the summer.
Mm-hmm.
And then agreeing to pay X amount of dollars for the additional time and burden on the other household. Is it possible to agree on this between the houses without going to court?
Yeah, you don't have to go to court, but you need to get a new parenting plan, and you need to modify your parenting plan, and you need to give notice that you're moving. You still need to do all the paperwork. You don't have to go to court, but you need to do the paperwork. You need to modify your current plan, and you need to get a new parenting plan, and you need to get a new support order to account for the reimbursements you're talking about. You totally don't have to go to court. Most relocations don't actually go to court. They either, well, it's not true. I would say relocations go one of two ways. They either blow up and go to court because the parties don't agree, or they work out and they never go to court. And yours sounds like it'll work out and never go to court, but you have to do the paperwork the right way. So you need to modify your current, you'd basically be doing an agreed modification. You'd be doing a new parenting plan. You'd be doing an agreed modification of the underlying support order, accounting for the long distance costs. So yeah, you would never need to go to court, but you need the paperwork all done for you correctly. And you still need to serve notice of intent to relocate. Even though you have an agreement, you still need to do that, to comply. Because the court will, when you go to enter agreed orders, the court will be like, well, where's your notice of intent to relocate? It's not filed. You have to do that. So you have to do that. Otherwise the court is going to like kind of raise their eyebrows, and you're going to have to deal with that. So you don't ever have to go to court, but you still have to file the proper paperwork. So hopefully that helps.
Okay, that clears our questions for now. If you want to finish up on the agenda.
Yeah, we're getting close. Cool. So that's great. Okay. Yeah. Question 2, I just want to go back to, before we got into the questions, I want to go back to talking really quickly about the durable power of attorney and the healthcare directives and powers of attorney. Those are so important, and like, who are they for? I just wanted to kind of key in on that. Like, they're for you, they're for your parents, they're for people you care about, and they're easy to do. And they're state specific. I've had people come to me and they're like, hey, I downloaded this off LegalZoom or Rocket Lawyer or whatever. Can you look at this and tell me if this is okay? And I'll look at it and it's completely not specific to Washington. And I'll be like, well, this is okay in Kentucky, or this would be okay. Like, well, I don't know, but it's not okay here. It doesn't meet the requirements for what would be okay here. You know, I noticed somebody had posted in the chat earlier that they had an experience where there was a notary at the hospital, but nobody could witness. And that was an excellent point. It's like I mentioned earlier, even if you can get a notary, if you can't get somebody to witness, it's not going to pass muster in Washington. I've had people come to me and they're like, oh, well, you can just notarize this, it's good to go. And I'm like, well, no, it's not. Because if you don't, we have different requirements than other states might have. So somebody will come to me sometimes and there's not even blanks for witnesses, or someone will say, or it'll have language that is completely not state specific. And they'll be like, well, I downloaded it, it should be fine. Well, no, that's not true. I actually tried a case in 2014 that was a nightmare, and it resulted in a decision where somebody actually downloaded a will, and they had it properly notarized, and they did all of these things, And then the will was invalidated later, and the Superior Court found that that person engaged in the unauthorized practice of law for doing these things. So crazy decisions can happen. The best thing I can tell you is have an attorney draft the documents. It'll save you time and money in the long run if someone challenges them. I'm the kind of person where before I ever became an attorney, I probably would have been like, oh yeah, I'm a smart person. I could download this, I could do it. But I know what I know and I know what I don't know, which is why I'm also the kind of person where if I sprain my ankle or I break my leg, I go to the doctor. If I need to do my taxes, even though I know quite a bit about taxes from doing divorce work, I don't do my own taxes. I tell my dad, who's a really smart guy, all the time, please don't waste your time and energy trying to do your own taxes because you're not a CPA. Get a tax professional to help you. If you're doing something like drafting a power of attorney, get an attorney to do it. Don't download it offline where you're probably using the wrong state's law and it could cost you tens of thousands, maybe even $100,000 in litigation later. Just do it right the first time. That's my best advice. Do it right the first time. I always tell people this too. I often draft pre and post nuptial agreements and cohabitation agreements. It's very much like drafting these kinds of forms. Make sure it's right because anyone can draft these things. Anybody. You know, you could draft something on a napkin and be like, hey, it's binding, notarize it. It doesn't mean it's gonna be valid if it's challenged or if you need it. These documents are like insurance. They're there for when you need them. You hope you don't, but if you need them, you want them to be valid, or you want somebody at a hospital to grab this and be like, yes, make the decision. You don't want someone to be like, oh no, this isn't witnessed. That's not helpful to you. You want it to be right the first time. So just get it done and make it be right the first time. I mean, that's all I'm saying. It's short-term sacrifice, long-term gain, you know? So last thing before I take any last questions is how to manage this. How do you manage all this? Like, it's kind of a nightmare, right? So how do you manage COVID? How do you manage things for your mental health? What do you do? Well, you did a good thing by listening to this today. You might have generated more questions than answers. I don't know, but you be patient. I'll tell you what, I have so many clients that just want their case over. I want your case over for you too. I do. I would love everyone's case to be over by the end of the year. But like I said, I had the pretrial conference the other day and the court was like, you know, these cases are really backed up. Can you just try to settle this, you know, on your own? Because it probably won't go to court in March anyway. And we're like, yeah, we're trying. Everything is extremely backed up. And so you can be patient with yourself. You can be patient with the court, even though we're not always as patient with the court as they would like, or we're not always as patient maybe with other attorneys as they would like, but we're trying to be patient with each other. Be patient with each other. You should also consider mental health. Melissa can chime in on that better than me, but I was talking to her the other day and, you know, telehealth is a thing now. I was talking to her about, I have such Zoom fatigue. I don't, this is fine because I'm not having to, I mean, I'm engaging with you, but you're not really engaging with me. So I'm not having to look at you and it's this whole thing, but you know, it's draining to do this all day. And a lot of people I know don't want to meet on Zoom all day, but you can still do therapy this way. And a lot of our clients, we recommend that they do because a lot of the reasons that attorney bills get so high, especially during COVID, is because they need someone to talk to. And, you know, I enjoy talking to people, but I'm not a therapist. So I tell people there are still ways that you can engage with mental health professionals in a secure manner. So I thought it'd be really good before we go and before we take last questions, if Melissa talked about telehealth, which is something I didn't even know about until COVID started. So why don't you tell them about it?
Sure, yeah. So telehealth is definitely a great option for therapy, especially during this time. You know, I've been a mental health professional for over 15 years, and prior to 2020, I was a bit resistant to meeting with people via video. I've just always practiced in person, and I really enjoy the in-person connection with people, and so I was always a bit resistant. But, you know, as with everything, I needed to adjust to this year to people's needs and to my own needs. And so I have begun meeting with people on telehealth, you know, early this year, and I'm still doing so. And it actually has worked out so much better than I thought, you know, and I have been able to establish some great connections with clients and keep people engaged and hopefully, you know, help people feel supported during this really hard time. Telehealth is secure. It's not like Zoom. It's a secure system that's used specifically for, you know, medical and mental health type of appointments. And yeah, I mean, I would really highly recommend trying to engage with someone during this time, even if it has to be on video and you would prefer to be in person. I just think it's certainly better than nothing. And this is a hard time. People are struggling. People have been really, really struggling emotionally this whole year. And if you have kids, your kids are struggling too, even if they don't know it. They might know it, they might not know it, but everybody's kind of dealing with their own forms of loss and grief throughout COVID. Confusing and conflicting emotions, you know, as we all adjust to this strange new way of life that we're in right now, that'll hopefully ease at some point. You know, and even more so if you're involved in a family law case, you know, you have that additional layer happening in it, you know, during the most difficult time, you know, in this world that many of us have ever experienced. And so everybody needs support. Don't try to tackle it alone. I mean, you know, utilize your support system in your life for sure. But consider talking to a therapist, in particular if you're trying to navigate custody issues and parenting plan issues, and you know, a divorce that maybe you have conflicting emotions about. Consider talking to a professional, because it is a really tough time. And you know, I just want everybody to be able to feel supported and know that telehealth is out there and worthwhile. And especially during the holidays, right? I mean, here's another time of year that's you know, difficult for people, especially again when there's divorces and separations happening. And then with COVID, again, it's just another layer. So yeah, for sure, access support, and the support is out there.
Yeah. Also, before we go, I know we have to go, but do we have a few more? I think we do.
Yeah, we do. Well, we have one more here. So not COVID related, but I have sole custody of my kids and an active parenting plan with my ex-husband. He recently said he wants to give up his paternal rights so he can stop having to pay child support and allow the kids to be adopted by a future spouse if I ever want to get remarried. Is giving up his parental rights a thing he can do? Why would I not want him to do this?
Sure, I can answer that quickly. Yes, he can. I mean, okay, yeah, he can do it. Here's the deal, just in a nutshell. Sometimes we do adoption, and usually when we do adoption, it's like a step parent adoption. It usually involves termination of somebody to put another person on a birth certificate. And so that might be a situation where, like you're talking about, he would be terminated to put somebody on, and it would terminate his obligation. If he just wants to do it now to terminate his child support obligation, that's pretty crappy. But I mean, that's my opinion. But yeah, he can terminate his parental rights, but he also, it doesn't extinguish any back support obligation. So if he has a back support obligation, then you know, he has that obligation to continue paying. The state could also object to him terminating his rights if he has a considerable support obligation, because there's no one to step into the shoes of paying that obligation. So if you're willing to let him do it, you can, if you just want to be done with him, because then he doesn't have any decision making over your child. He won't be in the way. I mean, if you don't have a good relationship with him, and if he's not super involved in your child's life, then maybe it's not a major loss. But if he is involved in your child's life and he contributes, that's kind of concerning. But I would say I wouldn't want it if he is a financial support, at least until if you have a new spouse later, then he could always, you know, the termination would be part of a step parent doing an adoption. That's a very normal thing. So you could tell him, hey, you could kind of stay on until I do have somebody. And then he continues to contribute until that time. I would also be worried about the impact it might have on your child. And that's another thing to consider. I don't know what that relationship's like between him and your child, but that'd be something to consider. But financially, it won't extinguish a back support obligation. So that's not your job to tell him that. But DCS, Division of Child Support, will continue to collect that obligation from him if he does have one. Yeah. Yeah. Oh, and I see it looks like there was a question about the relocation. I think somebody.
It looks like the person who asked that question had gotten, unfortunately, kicked off throughout part of your answer.
Sure.
So they just said, you know, they wanted to confirm. So fill out the relocation form. And was the other thing to file for modified parenting plan with the court?
Yeah, you need to do not just, the relo form. So you need to notice a relocation, but you also want to do, you're going to need to do an agreed modification. So agreed modification, I would do kind of the whole thing, because courts are pretty particular about making sure that kind of all the T's are crossed and the I's are dotted. So you're going to need agreed petition, agreed adequate cause, agreed parenting plan, agreed child support modification that includes the long distance expenses. So, and then agreed child support order and agreed new worksheets. So you need quite a bit of paperwork, but just make sure it's all done and you should be good to go. I mean, you definitely don't need to go to court. You just need to get all the paperwork done and you should be good. So, yeah.
And what if the modification is not agreed? Do we just propose what we want and go to mediation?
Yeah. If it's not agreed, then I would just say, yeah, if the modification's not agreed, what I would do is just serve the notice, because you got to get the notice served. But if you kind of have like an agreement on the move, cool, just serve the notice and then get your mediation scheduled as soon as you can and get your proposal together. And then hopefully you probably, if you guys generally have a fundamental agreement on the move, you can bang out all the details on the orders in your mediation. That should be relatively good. And then hopefully you can come out of the mediation with an agreement on everything, and then you can get final orders drafted. So, yeah.
All right, I've shared our screen here for some contact information, because we are needing to wrap up at this time. But keep your eyes out, because I think we're going to have another webinar in a couple of weeks.
Yeah, we're going to do another one before the end of the year. So I don't know if some of you guys joined us before. We were doing these pretty consistently, but I got a little bit of COVID burnout, and frankly, I just got really busy. So we're going to do another one next month, and we'll try to do these. Try to do them every month. We also have a meetup group that we do every month, literally religiously. So if you're ever interested in coming to that, and we've been before COVID. This is another thing. Before COVID, it was really great. We could do them in person. We'd buy you free food, and you could come and chat with us. I really enjoy that. Like I said when I started, I really like to talk to people in person. It's much better than this. But I've come to adapt to doing it this way, and it's not just me either. It's me. Melissa is there. We have a realtor there who is a divorce specialist, actually. She's a certified divorce specialist. We also have a certified divorce financial analyst from UBS there. We have a great group, and we meet once a month. You can find out about our meetup group on our website. It's on Facebook, it's on our website, it's on meetup.com. It's on our news and resources though on our website. And you probably signed up for our stuff, so you might get an e-blast about it. But we do that every month. We will be doing another webinar next month. And in 2020, I had all these grand ideas about doing more of this kind of stuff, but just like everything else, things were what they were. So thanks for coming today. Hope that you've got some information that was helpful to you. If you want to reach out or you have other questions, feel free to give us a call. Our number is 206-659-6839. You can see it on the screen right there. You also see my email address. Melissa's information is also right there. It was a pleasure. So I hope you have a good rest of your week. Take care. Bye-bye.